somewhere towards the end, you talked about the process that banks would actually be following so that it ends up in consolidation. And why is this so? Why is this such a lax attitude on part of the banks? Or is it that the asset quality of the banks on the whole is dwindling? When we were doing research and we were talking about willful default, we came up, one particular name kind of caught my attention, and I honestly had no idea, we had no idea that declaring willful defaulters criminals was talked about earlier than when we came to know about what Venkatachalam sir talked of. And this was Yogendra Yadavji and Prashant Bhushanji, when you demanded a white paper analysis of all the stressed assets and the NPAs to be brought forth into the public domain such that loan recovery could be actually accelerated. But I think it was almost 7 to 8 years back when you had made such a demand, and almost in the intervening period, nothing really transpired till the time 2 months back the list of willful defaulters was published by AIBEA. What must have happened? Why is it that the banks are trying to fall victims to their own procedures? It's a very difficult call to make here. I would request Yogendra Yadavji to deliberate on that.
This is the kind of work we need so much. I would also wish to specifically mention the Bankers Association, which has been doing, actually even in the pre-RTI days, when it used to be so difficult to get some of these lists. I remember the Bankers Association, even in those days, had published these lists and had done tremendous public service. We've had this utterly spurious and obnoxious debate on nationalism in this country a few months ago. And I find it so strange that we fail to invoke nationalism when it comes to issues of this kind. This is really what nationalism is all about. And what is being done to the country, to people's resources, if that is not Deshdroh, I do not know what is Deshdroh. And the entire debate in the country is about who said what, when 5 people gather and what slogan they shout in the vicinity of 5 more is something that threatens our nationalism. And these lakhs of crores of rupees being looted away is somehow not an issue of nationalism. So I'm here only to lend my voice to the point that many colleagues have made on the panel. It's not for people like me to come and pontificate on these technical issues. I'm here to learn. We have Professor Chandrasekhar, we have Guru Swamiji, we have Indira ji, and people like me should just shut up and listen and learn from them and see how what they tell us can then be articulated in public fora and taken to a much wider audience, which is what we should be focusing on. I would only make one tiny contribution and then shut up, having done the basic job of complimenting colleagues from PFPAC. Please continue this good work. This is so important. And the list that you have released, it hasn't yet reached public, and let's find ways of publicizing it from every rooftop, from every small seminar, every place on the street. Let's find ways of publicizing it. Let these amounts and names become street knowledge. That should be our job. I'm sure there are many other organizations which are happy to lend support to that, and on behalf of Swaraj Abhiyan, Prashant ji, who should have been here rather than me, I just wanted to say that yes, we would certainly be willing, in whichever small ways we can, to publicize it, to let there be public debate on these things. The one tiny contribution I wanted to make to the conversation was on the question that Venkatachalam ji also mentioned, namely farmers' loans. We've been in a court in the a case in the Supreme Court for the last 1 year. This is on the drought situation in the country. We took 12 states of the Indian Union to the court to say they are not performing their legal duties when it comes to the drought. The states obviously claimed they were, and one of the issues being debated is farmers' loans. What about farmers' loans during the drought period? The government of India produced these wonderful guidelines by RBI and the NABARD. The guidelines say how during natural calamity like drought, loan recovery should be shelved. Farmers should continue to be eligible for fresh loan irrespective of the loan that they have failed to pay, and their loans should be rescheduled. We said lovely guidelines. What about their implementation? And no one has an answer in the entire system. The episodic answer we get is the following. When the Reserve Bank of India guidelines say that farmers' loan recovery should be postponed by at least a year, this is the period when farmers are not only getting notices for recovery, this is when posters are being pasted in the villages with photograph of the defaulting farmers in areas that are drought hit, which according to RBI should not be any recovery at all. Not just photograph, just look at the efficiency of the government. In the Tehsil offices of Uttar Pradesh, and we have photograph of those offices, on the walls they have painted the names of leading defaulters. So you have names of farmers with amount like 2,50,000 rupees, 1,80,000 rupees. It's written on the wall of Tehsil, which is where every villager comes. Every person who has anything to do with government machinery comes to that damn office. And they have actually put up these large notices, wall writings, to say these are the defaulters. And this is when Mr. Vijay Mallya is planning his departure in the central hall of the Indian Parliament with nothing more than just 9,000 crore rupees in his pocket. Now, this is happening. The entire banking system cannot give elementary information. There is not even, we just wanted simple information. And this is not, who would answer us? The Supreme Court has been asking this question now for 4 months. Tell us, how many farmers have you given notices for loan recovery? No answer. How many farmers' loans have been rescheduled? And what was the total amount of loans? Interestingly, in the month of December, in one of the affidavit, Union government actually gives this answer. It says it's about 4,900 crore rupees amount of farm loan which has been restructured. But then they realized, we simply said, look, this appears to be 0.5% of the farming loan given in the country. That's roughly the proportion we had in mind. Then they realized they've committed a mistake. In the latest affidavit, they say they have no idea, they cannot provide this figure. This figure has suddenly gone underground. The entire system cannot tell you what is the overall farming loan, how much has been restructured, how many loan recovery notices have been issued, how much is being taken back, and what is the amount of fresh loan being sanctioned. On fresh loan being sanctioned, we had a Yatra from Marathwada to Bundelkhand in the month of May. We walked during the drought period to highlight the condition of the plight of the farmers. We ended the Yatra in the district Mahoba of Uttar Pradesh, where for whatever reason the district collector turned up. He turned up for that Jan Sunwai finally. He says, yes, I know in my district farmers are not being given fresh loans. And all this is on public address system. This is being video recorded. He says, yes, I know bank officials are doing so. I will take action. I'll do X, Y, and Z. Then he, of course, realizes what he had said. that it actually goes against all the norms and rules. He shuts up and the system refuses to give any information. So on the one hand, we have these loans being sanctioned, restructured, changed and everything. And on the other hand, farmers during a drought year, in the worst possible situation, are being harassed, are being squeezed, are being asked to pay back every penny, and every strong arm tactics is being used against the farmers. So while I welcome and applaud this report, I look forward to a second, even smaller report on the question of the farmers. And what is that? That's the other side of the coin. And we would be as keen. And let me also say, because the case is going on in the court, the next hearing is on the 21st. Any kind of help that we can get from within the system to actually disclose these figures and put it in the Supreme Court and say, this is what they are concealing from you, that would be a great help. Thank you very much. My compliments again.
Thank you so much, sir. And I assure you that we would definitely pick up the question of farm loans subsequently and would bring that up as an append to this report. Now, you're talking about loans which are in the public domain. I should also mention something here, that the harassment case of the borrowers generally compared with the corporates, you see that there is a prejudice as to why these borrowers are being chased, farmers being one amongst those borrowers, and even for an amount which is a pittance, they're most likely to be shamed. You never do that with the corporates. Why is that happening is probably the 1934 RBI Act, which protects them for business related interests. It's pretty hard to imagine why such is the case. But Yogendra sir has also demanded in the past for an independent body which would look into the cases which are brought forth for loan restructuring. And that's quite close to what the document talks about as the grievance redressal mechanism. And the issue is closely correlated with CDR, which Professor Chandrasekhar has talked about and also Venkatachalam has talked about. So did Yachuriji. So if this is the scenario on the one hand, the scenario on the other hand is to be looked through this whole process of restructuring. Is it really being looked at? Going back to UPA 2 government, Indira Rajaraman talked about a particular window, an online mechanism that brings forth for consideration all the loans which are in for restructuring, but with a cap of 1,000 crores plus. But there is a peculiar case of transparency in this case which gets breached. It is applications going in for clearances and applications coming out after clearances. No one has an idea. If at all there is an idea, the time lag is such that we cannot really come to a conclusion as to what would be the reason behind this. Are restructured loans such a menace here? I would like Dr. Indira to deliberate on that.
Yes, I do want to make a very specific recommendation for transparency going forward. Going beyond what I had said in that article. Actually, I wrote about this in another article about 2 years ago in the Business Standard. But before I go into my suggestion, let me lead into what I'm going to say with some definitional issues, particularly bearing on this excellent report that you've written. You know, I agree with all these previous speakers who refer to collusion and outright corruption, actually, which has landed us in this specific situation. But when you're going into advocacy and speaking and arguing, especially before the court on such issues, we have to make absolutely we have to be absolutely careful that you know, our definitions are correct and our understanding of the situation is absolutely technically correct. So in the first place, when you're making comparisons of NPAs over time, it is extremely important to move away from absolutes measured in rupees crores. To say it was 50,000 crores plus in March 2007 and has progressed to 5 lakh crore plus today does not quite convey the change over time, because there has also been an underlying change in the denominator with respect to which that figure must be normalized. So always when you're speaking of NPAs, referring to NPAs, please express it as a percentage of the underlying aggregate of gross bank assets. Okay? That's one thing. The other is, even when you look at this normalized aggregate over time, you have to watch out for definitional changes, changes in regulatory classification, which make comparisons across that divide very dangerous unless you're aware of what has happened. And there was such a definitional divide on 1 April 2015. This was notified nearly 2 years prior to that by the then, during the term of the then Governor Duvri Subbarao on the 30th of March 2013. The reason I'm mentioning these dates is because these notifications are all in the public domain on the RBI website, and you can check them out. So what happened was, prior to 1 April 2015, it's absolutely true that restructuring of loans was legally permissible, according to RBI regulations. So what RBI did, starting from about 2011 or 2012, was that in addition to the row describing NPAs as a percentage of gross bank assets, there was another row which reported restructured assets as a percentage of gross assets. And the RBI, in its financial stability reports, always referred to the stressed assets in the banking system, summing across these two. Okay? So while it is certainly a fact that prior to 1 April 2015, restructuring was legally permissible, it was not being swept under the carpet. It was being reported, and it was one of the two figures which fed into the total of stressed assets in the banking system. In this notification that I referred to, 30th May 2013, banks were given a 2-year lead over which to adjust to a change, a definitional change that was going to come in on 1 April 2015. And this definitional change was quite radical. It said that after that date, any loan which is restructured will automatically be termed a non-performing asset. It will automatically transfer into the NPA category. And that is why, when you look across that divide, you get, at the end of March 2015, you get NPAs at 4.6% of gross assets. And at the end of March 2016, which is 1 year after this definitional change came into effect, NPAs have jumped to 7.6% of gross assets. It's very important to remember that this was a definitional change. It's not as though there was a huge explosion of NPAs during this particular year. It is because restructured assets, starting from 1 April for a whole year, had been classified as NPAs and not as restructured assets. Now, of course, you're going to continue to have restructured assets for some time, because these are assets which were restructured before that date. But they will be a steadily declining percentage of gross assets because they are fixed and dwindling as a percentage. So as a result, at the end of March 2015, restructured assets, which amounted to 6.5% of gross assets, by the end of March 2016 had fallen to 3.9% of gross assets. So when you take stressed assets, summing across the two, you have an increase certainly, but from 11.1 to 11.5%. I'm pointing this out so that in your advocacy, you're aware of all these definitional changes, and you look at the correct magnitudes for comparison over time. So that's the good news, if you want to call it that stressed assets of the past year from 15 to 16 didn't go up from 4.6 to 7.6. It actually went up from 11.1 to 11.5, a smaller increase, but an increase nevertheless. Now comes the bad news. And that leads into my transparency suggestion. At the same time, in that as this regulatory tightening was being done in that 30th March 2013 notification, 30th May 2013 notification. There was also, at the same time that this regulatory tightening was being done, there was a loosening of regulation in another dimension, and that is what I want to focus on. See, what happened was, when this regulatory tightening was under discussion, banks and borrowers came to the RBI as the banking regulator and said, it's all very well for you to say that henceforth, after 2 years, you're going to classify restructured loans as NPAs. But much of this restructuring is not the fault either of the bank or of the borrower. It's a result of the fact that they are not able to get government permission for the start of commercial operations. So in every loan agreement, there is something called the date of commencement of commercial operations, DCCO. It's only when a project begins its commercial operations that the schedule of payments can be built into the loan, because it's only when they're earning something that they can actually pay some interest to the bank. So these borrowers said to the bank and to the banking regulator, they said, our DCCO cannot be respected, the one that we wrote down in the loan agreement, because we are not able to get government permissions. And what are these government permissions? Pani, Bijli, land, labor department, whole range of them. Now, of course, there is a different issue, that the very delay in government permissions may itself be a result of collusion between the borrower and the government department. Because the borrower himself may be interested in having a delay in commercial operations so that he can use the money that he has gathered from this loan as equity for some other loan that he's taking from some other bank in the banking system. That's a different issue. But the RBI as the banking regulator took this on board at that time. And they said, all right, a delay in the DCCO up to a certain limit will not be considered as restructuring. It will be treated just as rescheduling. And I'm calling this bad news because loans which have been rescheduled in this way are not going to get into the stressed assets totally, because they are not even being called restructured. And this period of permissible delay in the DCCO was actually further enhanced in a notification dated 26 June 2014, during the period of Rajaraman. It was substantially enhanced. So as things presently stand, a delay in the DCCO beyond what is written in the loan agreement by up to 2 years in the case of a non-infrastructure project, and up to 4 years for an infrastructure project, will be permissible, and that loan which has been rescheduled for that reason will not be called a restructured loan, and obviously after 1 April 2015 it will not be called an NPA either. So this is bad news, because it tells us that the 11.5% that we have as the percentage of stressed assets at the conclusion of March 2016 does not measure the full extent of assets which are imposing stress on the banking system. Because remember, if a loan is rescheduled because of DCCO delays, it's all the same to the bank whether it is restructured for some other reason or not. They are losing interest income and they are bleeding. And that is what concerns us. And because of this regulatory relaxation on this particular dimension, unfortunately, we don't even have a quantitative measure of this. We don't know what further percentage over and above the 11.5% is actually a stressed asset within the banking system because of accommodation to DCCO delays. So here is my very, very specific suggestion for transparency in this respect. I would venture to say that the Indian system is probably one of the very, very few systems in the world where failure of government to grant permissions for the start of commercial operations is itself imposing stress on the banking system. I mean, our country is probably quite unique in this respect. So this suggestion I made 2 years ago was the following. And I believe this suggestion I'm making can be followed without any damage to the confidentiality of the relationship between the bank and its clients. So what we need is a publicly available database on which all loans in excess of a certain size, so as to keep it manageable. Let's make that 5 crores, okay? 5 crores is the big borrower limit, okay? For all loans above a certain size, banks must be required to compulsorily report to this public database the following information. We don't need the name of the bank. We don't need the name of the borrower. We don't even need to know the size of the loan, other than to know that it is above 5 crores. What we need to know is, we need to know the date on which the loan agreement was signed. We need to know the sector in which it fell, iron and steel, power, airports, telecom, whatever it may be. The location, it's very, very important. The state, the district, location stroke S, there may be multiple locations. So we need to know the date of the loan agreement, the sector, the locations, and the DCCO in the loan agreement. That's very important. Then, we need to know for each such loan a listing of all the permissions they need in order to start commercial operations. This will vary by the sector of the project, possibly even by the location. And against each one of these, we need to know the date on which that permission was sought and the date on which that permission was eventually granted. Is there anything wrong with seeking this kind of information? Nothing at all. Nobody's confidentiality is being violated at all. We don't even know who the borrower is. We don't know who the bank, which the bank is. Once we get this information, we will finally get a handle on the extent of misgovernance in this country, the extent to which government itself is at fault for not granting simple permissions with which this project, which has been sanctioned by a bank, it's apparently a project above board, is not allowed to begin commercial operations, and to that extent is imposing stress on the banks. Among other things, we will know which are the delays, which are the biggest culprits. We will also know the differences between states in terms of this, and it will bring to light the most egregious aspect of government permissions in this country, is that, which, as you know, is that these permissions are marketized in most states. So we will bring to the fore, to public view, this very, very invisible and murky part of government operation, business operation, the nexus between the two, and finally get a handle and hopefully improve the function of both government and banks in our system. Thank you.